Hello, everybody.
Good afternoon. Are you Stephen Bowers?
Yes, ma'am.
Bowers, we're on the record in case number 25-5613FY. You're appearing for arraignment purposes this afternoon. You're appearing with Ms. Ferrara Wilbur, the defense attorney available through the Indigent Defense Counsel, who will be here to assist you. She's not yet had an opportunity to speak with you, so I'm going to place you and Ms. Ferrara Wilbur in a breakout room, place where you can have a private conversation with her so that she can go over the issues regarding the arraignment before we get started.
Okay, thank you.
You're welcome. Mr. Olson?
Yes, Your Honor.
The complaint names Lisa Bowers, and the facts and support say it's Felicia.
It would be Felicia would be the correct name, Your Honor. Does the court have the complaint dated today, or is that the weekend complaint?
No, this is today's.
Okay.
So the witnesses are listed as Lisa Bowers and Chase Matthew McNeely, and the count one alleges Lisa Bowers.
See, I'm looking at one that says Felicia Lynn Bowers. I wonder if we've resubmitted. This is a felony.
It's possible. The warrant was authorized in this, the one that I'm looking at on the 24th. We received it today.
Okay, yeah, that's the one I'm looking at. I don't know.
And I'm looking at the complaint. You might be looking at a warrant.
I'm looking at the complaint, so maybe the warrant was incorrect. Because our complaint names the victims as Felicia with an F, and count one is Felicia Bowers, and count two is Chase McNeely. Your Honor, I'm looking at what was sent over on. It looks like we may have filed a corrected complaint. The complaint now in our system has the names correct. But I do see that the original complaint that was sent over had the name of Lisa Bowers. It should be Felicia Bowers. And so I think we've corrected that and submitted a new complaint.
Okay, thank you.
We probably should have made it an amended complaint to note that correction.
Yes. Thank you. We are on the record in case number 25-5613FY. And Ms. Ferrara Wilbur, did you have opportunity to review allegations on the complaint, nature of the offense, and the possible maximum penalties with Mr. Bowers?
Yes, thank you. We did have the opportunity to review the complaint as well as his rights in this matter. At this time, Mr. Bowers waives a formal reading, pleads not guilty, and requests court-appointed counsel.
Thank you. Mr. Bowers, in order to complete a petition for court-appointed attorney, I need to place you under oath and ask you some questions. Please raise your right hand. And you swear that the information you're about to give me will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you, and you're welcome to lower your hand. Mr. Bowers, what is your phone number?
231.
And what is your mailing address? Okay, well, you won't be able to go back to that address, so where will you be staying and receiving your mail?
Traverse City,
And
Michigan.
what city? Thank you. Do you also use an email address?
Yes, it's at Gmail.
Are you working?
I was, yes.
Where are you employed?
Sheeran Custom Construction.
What's your average take-home pay?
It was about $900 a week.
Do you receive any other source of income or assistance?
We get state assistance.
Do you own a vehicle?
Me and my wife own a vehicle.
Do you have any money in a checking account or savings account, any cash on hand or any digital currency?
I honestly, I don't know how much money we have, Your Honor.
So I will appoint an attorney for you. I'm going to remind you that you have the right to remain silent. Anything that you say orally or in writing can be used against you. You have the right to have an attorney present during any questioning. If you could not afford an attorney, the court would appoint one at public expense. You have the right to have the attorney present during all subsequent court proceedings. You have the right to a preliminary examination. In this case, it will be scheduled for October 14th. It would be at 11 a.m. with Judge Cooney. Also, on October 7th, you'll have a probable cause conference. Ms. Ferrara Wilbur, is there information you would like me to know regarding bond? And we do have Mr. Olson here for the people as well. We'll start with you, Ms. Ferrara Wilbur.
Yes, thank you. I did have the opportunity to review the practice report with Mr. Bowers, and at this time, he leaves bond to the court's discretion. Thank you.
For the people, Mr. Olson?
Yes, Your Honor. As background, the court may or may not be aware of this, but Mr. Bowers is being held for a PPO violation. There was a hearing before Judge Witten for an arraignment on that PPO violation, of which Ms. Felicia Bowers was the protected party. That hearing actually occurred yesterday on September 24th. In an unusual course of events, but appropriately so, Judge Witten set a bond of $50,000 cash or surety, as well as ordering no contact with Felicia Bowers or any of the minor children. Despite before that order was even, the ink was even dry on that order, the defendant made 8 more phone calls to the victim in this case just yesterday. He's called her again this morning. On the day before the PPO arraignment hearing, he called her twice. And between the time of his arrest on the PPO violation and to the 23rd, he called her 25 times. This is a pattern with Mr. Bowers. I'm familiar with his previous domestic violence case in which he pled guilty earlier this year. While that case was awaiting trial, he assaulted Felicia Bowers again, which resulted in a second domestic violence charge. That charge was dismissed with a plea in the first domestic violence case that was resolved this past spring. And in part, the difficulty of that case was, again, that he literally made hundreds of phone calls with the victim in that case and had convinced her to provide information that was contrary to her statements that she had made at the scene. And interestingly, in that case, very early on when he was arrested in his previous domestic violence case, the facts of that case involved him putting his hands around the victim's neck and pinning her to a bed. He called a friend, said that the victim, he told the victim that he was going to be ending their relationship and that she was upset and she caused those marks on herself and called the police, planting a false story in others. He also used a friend named Richie to relay messages to her indirectly, used Richie to have video calls with his friend Richie, in which the victim then appeared in the video calls contrary to his no contact order in that case, and then continued to talk to the victim on a different phone throughout the pendency of that case. And then in this case, again, the facts involve that he placed his hand around the victim's neck, pinned her up against a wall when their 13-year-old son tried to intervene. In this case that's before the court, he struck that 13-year-old child in the face. He then prevented the victim from calling 911 and then left the scene. And interestingly, again, after he was arrested on the PPO violation, he calls a third-party friend of his and begins another false story that the only thing that he remembers is being hit in the back of the head, and apparently he's now being accused of hitting somebody in the household. And again, he's continuing to contact the victim and in a very manipulative way. I think that the bond in this case, Your Honor, we're asking for $100,000 cash or surety because he's already demonstrated within 24 hours he's not going to abide by any conditions that the court is going to impose. He's not abiding by Judge Witten's order not to have no contact with Felicia Bowers. He's now proven that. In addition, he's just a danger. These strangulation type cases present a very serious risk, combined with the charge of preventing her from calling for help in 911. and it's just repeated behavior within a 12-month period, essentially. And Your Honor, we would ask for this condition of a no contact to be in place as to Ms. Bowers and the minor children, and to include that order be in immediate effect to include while he's incarcerated or held in the Grand Traverse County Jail pending this case, should he not be able to post bond. In addition to that, we would also ask that it be made clear that that includes contact through third parties as well.
Thank you. Mr. Bowers, would you ask the corrections officer to step in for a moment, please?
Yes, Your Honor.
Can you tell me if there is a way for the jail to block phone numbers?
Yes, there is.
Okay. Thank you.
You're welcome.
So, Mr. Bowers, your bond is going to be a $100,000 cash or surety bond. Conditions on the bond are that you may not use nor possess any alcohol, any illegal substance, any controlled substance, including marijuana, any mind or mood altering substances, or any non-prescribed medication. You would submit to discretionary testing whenever requested by a police officer or any court personnel, so you may not refuse. You'll have no contact in any manner whatsoever with Felicia Bowers and or Chase McNeely, and the 11-month-old child that you have in common as well. That means no phone calls, no messages through other people, no mail. You may not text, message, nor through any social network have any contact with any of those individuals. You will stay 500 yards or more away from each. You may not be at any address that they are or may be. Specifically, you may not return to. The jail is going to be ordered to block any number that's used by Felicia Bowers, and hopefully the prosecutor's office can provide us with those phone numbers. This order is in effect as I speak these words. The next step would be that the court would request that you be placed in a solitary cell so that you would not be able to communicate with other jail inmates or phone messages. So this is up to you at this point, Mr. Bowers. You know, your future is absolutely in your hands. You will either respect the court's orders and comply, or you'll find yourself in a situation where you will not be able to violate the conditions by not being able to access communication devices. You will have no threatening, intimidating, harassing, or violent behavior towards any person. You'll be respectful of all court employees and care providers during the course of your case. If you are able to post the bond and release, you will be supervised by Community Corrections Pretrial Services. You will be placed on a tether, a GPS tether. You will be on home arrest. The only release from that home arrest would be by verification through Community Corrections of work, court appearances, and communication with your attorney. Ms. Ferrara-Wilbur, do you have any questions?
Not at this time, thank you.
And Mr. Olson?
I can provide one number right now, or I can provide it directly to the jail, whichever the court prefers.
Okay.
The number to be immediately blocked that I'm aware of right now is 231.
I have that.
Where did you get that number? Thank you. And there may be others that will be coming your way for the jail there.
Yes, Your Honor.
Thank you. So for right now then, Mr. Bowers, you are all set. Mr. Olson?
Yes, Your Honor.
Are you here?
I'm here on Mr. Bowers again. When the court
Oh.
is finished with the rest of the
Okay.
arraignment, I'd like to address that again, Your Honor.
Okay, thank you. So for right now then, Ms. Foster, you are all set.
Awesome, thank you.
Control one heading
Do we
back
have
to
one more
105.
to see? That's Mr. Ryder.
Yes. And I did go ahead, Your Honor, and have that number blocked for Mr. Bowers.
Thank you.
You're welcome.
Thank you.
You're welcome. Mr. Olson, do we need to have Mr. Bowers back?
Yes, Your Honor, I would request that he be brought back to the room.
I need to get.
Thank you.
Get a phone number out of it, because I made bail.
Okay, yep,
I need to get some money down there.
we'll get that. Let me finish up with this courts and I'll,
Alright.
we'll get control at one heading back to 204.
Sir, may we see Mr. Stephen Bowers one more time, please?
Yes, absolutely. One moment, Your Honor.
Thank you. Mr. Bowers, we're back on the record in case number 25-5613FY. Mr. Olson?
Yes, Your Honor, thank you. I wanted to readdress bond again. Following the hearing that we just had, and after providing to both the court and the jail staff that number on the record that was to be blocked at 2:19, right after the hearing, Mr. Bowers made a phone call to that number. The call lasted about 3 minutes and 42 seconds. He spoke to the victim, that the protected party in this case advised her that he was being put in solitary confinement because of communicating with her, and proceeded to discuss the facts of the case, and clearly not in compliance with the court's order. I think this would be, first of all, an indirect contempt of court, which we would need to motion up properly before the court. But I wasn't sure if the court had ordered solitary as an immediate condition, or if that was in case he violated. But I would be asking for additional provisions in his current custody status to restrict him from all outside phone calls and communication, with the exception of his attorney.
Magistrate, could I please have a breakout room with Mr. Bowers?
Yes, ma'am.
Thank you.
For Wilbur,
Yes, ma'am.
is there anything that you would like me to know regarding amending the bond conditions?
I guess at this time, then, would the court be treating this as a new bond violation, or a bond violation? I know that Mr. Bowers would like a hearing regarding these allegations with his counsel that was previously appointed in regards to the bond at this time. Pending that hearing, we would request that it be the least, I would ask that the court adopt Mr. Olson's recommendation of just restrict it, no phone access other than contact with counsel versus solitary, pending a hearing at this time.
Thank you. So I guess I would ask that the correction officer step in once again. I am going to order, Mr. Bowers, that you will have absolutely no access to any phone. Again, no directing other people also to send messages or to use their phone time. And I don't know how the jail staff is going to be able to accommodate that, but I am ordering that you have absolutely no allowance of phone contact except for with your attorney. I believe that you do pose a risk absolutely to the alleged victims in this case. And because of that, however it is that the jail can provide that safety as well, I am ordering that you have absolutely no phone use, no communications through other people. you know, I guess I don't know how to underline and underscore and let you know how serious the court is with regard to this, but I'm hopeful that you will understand. So I'm not going to order that you'll be placed in solitary confinement, but if that's the only way that the jail staff can ensure that you have no contact with any phone, then that's what the jail staff would have to do, because they need to be compliant, I guess is the best term, with the court's order that you not be able to have any phone usage except for calls to your attorney.
And Your Honor, we can accommodate that.
Thank you. With regard to violation, that may either be through the motion from the prosecutor's office for the indirect contempt, and or by a motion on the court's behalf for violation hearing. And I understand that he is requesting that hearing with regard to the bond violation, and we'll get that scheduled, or through the prosecutor's office motion for contempt. Is there anything further, Mr. Olson?
No, thank you, Your Honor.
Ms. Ferrara-Wilbur?
Not at this time. Thank you.
Thank you all. We are all set, and you are free to go.
Thank you.
Right this way.
Be safe, be well, sleep sweet, and much love.